Hello, I'm Travis Sasser, and in this video I will be discussing lawsuits and how those interact sometimes with bankruptcy cases. A lawsuit in North Carolina is commenced with the filing of an action with the clerk of court. There's three different courts. There's magistrate court, district court, and superior court. In a magistrate action, the defendant does not have to file an answer. There is a court date that's already set automatically. And to defend a magistrate court action, the defendant simply needs to appear at the court date, either with or without an attorney. For a district court or superior court action, the defendant has 30 days to file an answer, and it's very common for the clerk of court to allow an additional 30-day extension of time if that is applied for. And an individual can either represent themselves or they can have an attorney represent them. A registered entity, such as a corporation or an LLC, is required to be represented by an attorney. If a judgment results from a lawsuit, then that is valid for up to 10 years. And a judgment accrues interest at 8%. A judgment can also be renewed for an additional 10 years after the first 10 years has expired. The judgment can create a lien on real property. A judgment it can be satisfied either in part or in full by making a payment to the clerk of court where the judgment is entered. If a judgment creditor wants to execute on a judgment for an individual, they first must give that individual the opportunity to claim their exemptions. And so the way that works is the sheriff serves this form. It's a 4-page form, and the judgment debtor then has to fill it out and file it within 20 days of service and serve a copy on the judgment creditor's attorney. And this form allows the debtor to list their assets out that they intend to protect. And it also requires the debtor to list other assets that they own that are not being claimed as exempt. And hopefully the judgment debtor is able to fit all of their assets under these forms. And if that's true, then the judgment debtor is what is called judgment proof or collection proof or execution proof. It just simply means there are no assets to take, at least for the time being. However, a judgment execution can occur at any time for the pendency of the judgment, which again can be up to 20 years. So even if a judgment debtor is judgment proof immediately after the entry of the judgment, that doesn't mean that they always will be judgment proof. That could actually change. A bankruptcy filing not only can stop a lawsuit, but it can actually often discharge a entered judgment. Now, there are some exceptions for things like domestic obligations or debts incurred through fraud or defalcation of fiduciary duty or willful or malicious injury. But most of the time, a judgment can be addressed in a bankruptcy just like any other liability can be. And in many instances, a judgment lien on the debtor's real estate can be avoided. That's not always true, but it often is true, namely when the exemption is being impaired. So as an example, if a debtor is not married and they own a piece of real estate, their residence, that has a value of $300,000, and there is a mortgage against the property for $270,000, and the judgment debtor, or the bankrupt debtor rather, has claimed their $35,000 homestead exemption, then the judgment lien can be fully avoided. So a judgment can often be addressed with a bankruptcy filing, and our firm offers free consultations to discuss these options and the way that this works. We're happy to talk to you about it. We offer those both in person and over the phone and over video. Our phone number is 919-319-7400. But regardless, if you are sued, that is a serious matter and it should be attended to, and it would be a good idea to talk to a competent attorney who can discuss possible defenses to the lawsuit, possible counterclaims that can be filed, or even just the implications of having a judgment against you. Thank you so much for listening.